Hello everyone, myself Professor Dr. Rajashree Jawale, Assistant Professor, DG College of Commerce, Satara. Dear students, today we are going to talk about performance of contract. In the earlier lecture, we have seen part 1 of performance of contract. In this lecture, we will talk about part 2 of performance of contract. So we have already discussed about what is performance of contract, actual performance and the attempted performance, section 37 of Indian Contract Act 1872. Then we have also talked about tender or offer of performance. So tender is nothing but offer of performance. We have also seen essentials of a valid tender. Then we have also seen essentials of a valid tender, and that we have seen that valid tender where there are unconditional terms and the proper time and the place, opportunity of inspection is there, tender should be as a whole, then proper form should be there by proper person, then specific willingness should be there, and the joint promises, that also we have seen in the last lecture. We have seen who can demand the performance. So the promisee, the agent and legal representative, all these persons can demand performance. We have also seen time and place of performance. Section 46 to 50. There are rules of performance. So reasonable time should be given, and that time should be specified one, and the promisee and the promiser can make an application or to apply for the specific performance or performance, and the manner of performance also needs to be provided. So in today's lecture we will see devolution of joint liabilities and rights. So these are the section 42 to 44 of the Indian Contract Act, which discuss about devolution of joint liabilities and rights. So what is this actually? So sometimes two or more persons enter into a joint agreement with one or more persons. For example, suppose A and B jointly promise to pay rupees 2000 to C and D. Here A and B are the joint promisers and C and D are the joint promisees. In such cases, the question arises as to who is liable to perform and who can demand performance. The rights and liabilities of the joint promisees and joint promisers are discussed in this particular devolution of joint liabilities and rights. So these are under section 42 to 45 of the Indian Contract Act. So what are these rules? So there are certain rules. So we'll talk about A, devolution of joint liabilities, and B is about devolution of joint rights. So first we will see devolution of joint liabilities. So here, when two or more persons have made a promise, all of them must jointly fulfill the promise. If any of the joint promisers die, his legal representative will be jointly liable along with surviving promiser to perform the promise. Thus, after the death of the joint promiser, his liability devolves or passes on to his legal representative. So here, devolution of joint liabilities and rights, that means transferring or passing of joint liabilities and rights to their legal representative. If all the original promisers die, then the liability transfers or passes or devolves onto the legal representative of all of them. They are jointly liable for the performance of the promise. The next is what? The promisee can compel any one or more of such joint promisers to perform whole of the promise. Next is what? Where one of the joint promisers has performed the promise, he is entitled to claim equal contribution from other joint promisers. If a joint promiser makes a default, then the remaining joint promisers must share the loss equally. Thus, the liability of joint promisers is joint and several. That means they are together liable for the act. The release of one of joint promises by the promisee does not discharge the other joint promises. Thus, if one of the joint promises becomes insolvent, the other joint promises will not be discharged. So this is about devolution of joint liabilities. Now we'll talk about devolution of joint rights. That means passing of joint rights. The nature of rights of the joint promisees will be as follows. 1. All the joint promisees can claim the performance of the promise from the promiser jointly. Second, the benefit of the promisee devolves or passes on the legal representative of the deceased promisee. Therefore, if any one of the several joint promisees die, his legal representative along with surviving promisees can claim performance of the promise. So here the role of the legal representative is very important. Third, if all the joint promises die, the legal representative of all of them, they must join together to claim performance of the promise. So these are the rights and the liabilities that can be passed to the legal representative. Now we'll talk about reciprocal promises. Section 2, subclause F of Indian Contract Act. So here the promises which form consideration or part of the consideration to each other are called reciprocal promises. For example, A and B promised to marry each other. These are reciprocal promises. A's promise is a consideration for B's promise, and B's promise is a consideration for A's promise. So here a promise against a promise is a good consideration. When there are reciprocal promises, it is obligatory for each party to perform his reciprocal or his promise and also accept the performance of the other party's promise. Here each party is promiser as well as promisee. So here in this case A and B are promisers also and promisee also. Now we'll see the another part, that is types of reciprocal promises. So all these types are recognized in the very famous case, that is John versus Beckley. The reciprocal promises have been classified by Lord Mansfield in Johns versus Beckley case. So A, B and C, these are the types of reciprocal promises. Mutual and independent promises. When each party has to perform his promise independently without waiting for the performance of the other party, the promises are mutual and independent. Such promises are rare and therefore they have not been provided in the Act. For example, in a sale, A agrees to pay the price of goods on 15th and B promises to supply the goods on 22nd of the same month. The promises are mutual and independent. Now we'll see mutual and concurrent promises. Mutual and concurrent promises, when both the parties have to perform their promises simultaneously, that means at the same time, then they are mutual and concurrent promises. For instance or example, sale of goods for cash or mutual promises to marry. These are the examples of mutual and concurrent promises. Now we'll see mutual and dependent. Third type. In this, when the performance of the promise by the promiser depends on the prior performance of the promise by the promisee. The promises are mutual and dependent. For example, X agrees to build a house for Y. Y agrees to supply the required cement for the construction of the house. The promises are mutual and dependent. So these are the three types of reciprocal promises. Now we'll see about the next part, and that is rules regarding reciprocal promises. So there are certain rules which are very important. The rules are contained in section 51 to 54 and 57 of the Indian Contract Act. They are: first is simultaneous reciprocal promises. When the contract consists of reciprocal promises to be performed simultaneously, the promiser need not perform his promise unless the promisee is ready and willing to perform his promise. For example, A and B enter into a contract whereby A shall deliver certain goods to B and B to pay the price on delivery. Here, A need not deliver the goods to B unless B is ready and willing to pay for the goods on delivery. Similarly, B need not pay the price unless A is ready and willing to deliver the goods. Next, we'll see about order of performance. For example, X and Y agree that X shall build a house for Y at rupees 1 lakh. Here, X promise to build the house must be performed before Y's promise to pay for it is performed. So here, where the order in which the reciprocal promises are to be performed is expressly fixed by the contract, they must be performed in that order. If the order is not fixed, they shall be performed in their natural order. Then third, effect of preventing the party. Where one party prevents the other from performing its promise, the contract becomes voidable at the option of the party so prevented. Such party is entitled to get compensation from the other party for any loss suffered due to non-performance of the contract. So here that can be rectified. The compensation should be given to the aggrieved party. For example, A and B entered into a contract that B shall carry out certain work for A for rupees 10,000. B is ready and willing to do the work, but A prevent him from doing so. Here, the contract becomes voidable at the option of B, and also he is entitled to claim compensation from A for any loss suffered. Next, we'll see failure to perform promise. In this case, when the nature of the promise is such that one of them cannot be performed or its performance cannot be claimed till the other hath performed his promise, then if the other party fails to perform it, he cannot claim performance from the first party. In such case, the other party must make compensation to the first party for his failure. Now we'll see example. Suppose A agrees to build the house for B for certain amount provided B supplies necessary material for the work. When B refuses to supply any material and the construction could not be done, here B cannot claim the performance, and besides he will have to compensate A for any loss caused to him. Next is one legal and other illegal part. When a contract consists of two parts, one part legal and the other illegal, and the legal part is separable from illegal one, then the court will enforce only to the legal part. That means court will say that only legal part will be enforceable by the court, or that has to be performed. So court will make compulsion on the party. Now we'll see example. X agrees to sell his house to Y for rupees 50,000. But if Y uses it for gambling purpose, he shall pay rupees 1 lakh for it. Here the first part is legal and second part is illegal. Only the legal part can be enforced. Now we'll see alternative promise. So here, when there is an alternative promise, one branch of which is legal and the other is illegal, then in this case only the legal branch will be enforced. Now we'll see the example. When there is X and Y, they enter into an agreement by which X has to deliver to Y either wheat or smuggle opium. Here only the contract to deliver wheat can be enforced. So in this way there are certain rules. If we look into this rule, the legality of promises or the contract must be seen. Then there are certain obligations on the parties that they need to be performed according to the needs of the contract or the agreement. So reciprocal promises, both the parties are equally liable for the rights and the liabilities. Now we'll see appropriation of payments. These are mentioned in section 59 to 61 of the Indian Contract Act. So express appropriation by debtor, implied appropriation by debtor, principal amount and interest, no express appropriation, order of appropriation, and finally dates of equal standing. We'll see first express appropriation by debtor. If the debtor at the time of the making repayment expressly instruct that payment should be appropriated to discharge a particular debt, the creditor should appropriate the amount accordingly. For example, X owes Y several debts, of which one is for rupees 950. Y writes to X and demands payment of this sum. X sends to Y rupees 950. This payment should be applied to discharge that particular debt only. Second, implied appropriation by debtor. If there is no express indication but the circumstances imply that the debtor intended appropriation to a particular debt, the debtor's intention must be followed. For example, X owes Y among other debts rupees 2000 upon a promissory note which fall due on 1st July. He owes Y another debt of this amount. On 1st July, X pays rupees 2000 to Y. The payment is to be applied to the discharge of the promissory note. The next is principal amount and interest. In the absence of appropriation by the debtor, the payment should be attributed in the first instance to interest and then to the principal. Next is no express appropriation. In this case, if at the time of making the payment, the debtor gives no express or implied direction, the creditor has got the option to appropriate the amount towards the satisfaction of any lawful debt. He may insist an appropriation in the chronological order. Next, order of appropriation. When neither debtor nor the creditor make any appropriation, the court will appropriate the payment towards one debt after another in the order of time. And finally, debts of equal standing. If all the debts are of equal standing, that is, of the same date, the payment shall be appropriated proportionately. For example, A owes B several debts taken on 1st January, rupees 5000, rupees 3000 and rupees 2000. On 1st April, A repays rupees 5000 but does not make any express appropriation. Here, the amount of rupees 5000 will be applied proportionately among all the three debts. The amount repaid is exactly 50% of the total indebtedness. So the amount will be appropriated as rupees 2500, rupees 1500 and rupees 1000 for the three debts respectively. So in this way, we need to understand the reciprocal promise. In conclusion, I would like to tell a contract creates legal obligations between the parties. If the parties fulfill their obligations, it is the performance of the contract. These are the references. I have used a book on business regulatory framework by Dr. J.S. Chowdhury, then Indian Contract Act by Avtar Singh, and some online material. Thank you.